All right. Welcome, and thank you for attending the State Office of Funeral Home and Mortuary Science Services stakeholder meeting via webinar today. The date is Friday, November 1st, 2024, and it is 10:04 a.m. Before we get started, I'd like to introduce the staff members from the division, professions, and occupations that are present today. My name is Nate Brown. I'm a regulatory analyst with the division. Also attending are Sam Delp, the division director, Jackie Arcelin, the deputy division director, Sarah Werner, a deputy division director, Zin Mayhew, the program director, Joseph Berry, an inspector, and Maria Rasconarana, regulatory coordinator. The division has transitioned to a platform that is 100% virtual, and we appreciate your flexibility. Dora makes decisions every day that may affect your life and your business, so your input is vital in the rulemaking process. Throughout this process, our goal is to create regulations that clarify and explain legislation, ensure minimum competency to enter and continue practice in the profession, and provide only what is absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Your input will be part of the information that goes to the director as he considers adopting revisions to the rules. More specifically, today the director is proposing revisions to the rules to implement the provisions of House Bill 24-1335 concerning the continuation of the regulation of persons related to the final disposition of deceased human bodies, and Senate Bill 24-173 concerning the regulation of persons providing mortuary science services. Specifically, revisions to existing rules 1.1, 1.2, 1.3, and 1.4, revisions to and renumbering of rules 1.5, 1.6, 1.7, 1.8, and 1.9, and proposed new rules 1.5 through 1.27. In addition, an additional purpose of this second stakeholder meeting is to allow the director to gather stakeholder feedback concerning the following specific questions, which hopefully you will have been able to see ahead of time in the notice that went out, I believe, late last week. Some of the questions being, the first one, how should the rules address the refrigeration requirements for facilities? How should the rules address operating capacity with respect to refrigeration? How should the rules address off-site storage of human remains? How should the rules address the process of natural reduction? And how should the rules address issues surrounding advertising? Specifically, should the rules include a provision requiring that in any advertising materials created or used by a registrant, the identity or identities of the owner or responsible party for the funeral establishment or crematory must be included, as well as a requirement to remove all signage from the premises of a funeral establishment or crematory that has ceased operations. So a little bit about the process. This meeting is being recorded, as you heard, and will be posted on the program's website by the close of business on Monday. As this stakeholder meeting is held solely via webinar, please raise your hand by using the hand icon within the Zoom app if you would like to speak, and we will unmute you so you will be heard by everyone. Or if you don't want to speak, you can type your comment into the question section, and then we will read it aloud. Before we start taking comments, I want to ask that anyone providing comments please state your name and the name of the organization that you represent, if any. Please feel free to provide either general comments on the rule changes or specific comments on the proposed language. Please limit your comments to no more than 3 minutes, and try not to repeat something that has already been said. Stating you're in full agreement with someone else works just fine and will be noted. Some last second housekeeping matters. If you are using the audio through your computer, please remember to put any phones on vibrate or turn them off. And whether you are using computer or phone audio, try to keep background noises to a minimum when speaking. Okay, with that, we will start taking comments and questions from the public. Again, if you want to be heard out loud, please go ahead, just raise your hand and we will unmute you on our end. The first hand I see up is Lenny Griffin. You should be able to unmute. Please go ahead. When you're ready, you'll have 3 minutes.
Hey, thanks for the webinar today. A couple questions. I'm Lenny Griffin. I own Griffin Funeral Companies. When does this House bill take effect?
Sarah, go ahead.
Yeah. It took effect on signature, so that was in late May, I believe May 28th, if I remember correctly.
And that was 2023 or 2024?
2024, yes.
I did see the fee increases for the funeral home registration have gone up over 500%. Were you aware of that?
Sorry, I couldn't find my unmute button. I apologize. Yeah, so the fee increases for funeral homes and crematories were part of this bill. They were noted in the fiscal note, which is available on the General Assembly website.
So you're aware they went from like 400 something dollars to 1750 per establishment registration?
Yes.
What are the licensing fees going to be per individual once you guys put this into effect? I believe you're saying that the licensing will have to be applied for in May. Is that correct?
Oh, for individuals, those fees have not yet been set. Fees are based on the cost of providing the program. So once those fees are set, they will be available on the website as people go through the registration process, but they have not yet been finalized. There are proposed or estimated fees within the fiscal note for Senate Bill 24173, and those are available on the General Assembly's website if you click on fiscal.
Okay. And what tax has been allocated to the program or to the Department of Regulatory Affairs for this House bill to support its structure and working?
There are no taxes. This program is supported by licensee fees.
So essentially what I'm understanding is we're to charge our consumer for the increase in fees. Is that correct?
Fees are that's up to you. That's up to obviously each individual business to decide on how they charge their fees. But this program and most programs within the Department of Regulatory Agencies are supported by licensee fees.
Okay, understood. Last question I have is I've read the bill. We've gone through everything. I know you guys are doing a bunch of changes, but okay, so outside of the licensing and the licensing requirements, where have we shown that we're going to change the regulatory process with maybe some permit closure processing or how we're going to close transportation or cremation or burial permits? We get the permits, but there's no permit closure process.
Permits are actually regulated by the Colorado Department of Public Health and Environment, so I'm not able to answer those questions, but that is something you could certainly reach out to them on.
I've gotten no return, but I just think that a lot of this could have been circumvented if we would have had a permit closure process. Maybe return to nature would have never been allowed to, for lack of a better term, just hold people around. So that's one of my main concerns through this process is that we do come up with some sort of a permit closure process. We can definitely get a permit, but it doesn't mean anything if you don't close it. And that's all I have.
Great. Thank you so much for your comments. Appreciate you taking the time to come out today. Right. Well, I don't see any additional hands at this point, so I will just kind of start scrolling through. I think we can maybe touch on some of the written comments that we've received, and I can kind of highlight some of the areas where we've made a few adjustments based on previous comments received, just with respect to some of the things that we've been looking at here. So one of the first things that we've done here is sort of update the definition of funeral service establishment, just noting that each of them will have to conform to local government zoning regulations and other applicable ordinances, just to make sure it's all in accordance with all applicable law. And if someone's not running a funeral home out of their bedroom or something like that. So it's based on one of the comments we received. I will pause there to see if any hands go up with regard to that.
Hey, Nate, just wanted to let you know we're not seeing the screen if you're intending to be screen sharing.
Oh, yeah. It should be sharing.
I can see it. Yeah, that's weird.
Would someone from the public mind just raising your hand to confirm if you can see that? Okay. Looks like we're getting some hands up. So Sarah, it might just be your computer.
All right, I apologize.
No worries. No worries. thank you all for raising your hand. And hey, there we go. I was gonna lower everybody's hand, and if you do want to speak, of course, just put your hand back up. But seems like everybody can see it, so I will keep going. I don't see any hands raised for that particular. Looks like we might have some. Okay, people are just saying. All right, so we will move right along. Oh, I did see a hand go up. Richard, I apologize for mispronouncing anybody's name, but Richard Hubler, please go ahead. When you're ready, you'll have 3 minutes.
Thank you. Just had a quick question actually as to how you foresee the zoning authority verification coming from a local jurisdiction. Like, how would that process work? Or is there a process, or is it simply just a requirement that they be in compliance?
Correct. Yep. So people should be in, excuse me, any facility should be in compliance with all state or all local laws, but that is something that is looked over or regulated on the local level.
So as part of the application or the processing on your end, you're not going to be expecting a zoning sign off or a letter from the local jurisdiction or any kind of written verification that they are in compliance?
No.
Okay. So representing a local jurisdiction, I guess I would just suggest as the final point is that that can be a bit challenging if folks are not maybe operating out of the bedroom, but out of a warehouse or doing something that's not fully compliant, and we're not aware of it because they haven't reached out to us. That's all I have to say.
Yep, thank you so much for your comments. I'll lower your hand on our end, but if you do have more to say, please, of course, go ahead, put your hand back up. Okay. Oh, I see a hand up from Blanca Eberhardt. You should be able to unmute on your end. Please go ahead when you're ready. You'll have 3 minutes.
Okay, thank you. Well, I have a general question. What are we abiding by currently? So I know that we're making the rules, they don't exist yet. But currently, are we abiding by the mortuary science code that's been in place?
Yeah, so we are abiding by the mortuary science code as enacted in May of 2024. So that is the law that is currently in effect. Registration of individuals has not yet begun, and that's kind of part of this rulemaking process. So once all the rules are in place and other things are in place, we anticipate beginning the registration of individuals. But facilities who are currently registered are expected to operate in accordance with the code as it is currently written.
From 2024.
That's correct.
Okay, just knowing like the things that aren't yet, the things that are still a work in progress don't apply, but the other things like maybe title protection, that currently applies?
Title protection as written in Senate Bill 173 is defined as being licensed. Since the licensure process is not yet in place, that is not fully enforceable. So those provisions are not yet in place. However, once licensure is required, that will be fully enforced.
Okay, so right now we're kind of in a limbo with that, just so I'm understanding correctly, because we had it in the mortuary code, and since that's non-applicable, and we're utilizing only certain parts of what was implemented on May of 2024, but because licensing hasn't taken place, it's kind of in a limbo and on hold, so to speak.
Yeah,
Okay,
so
gotcha.
in Senate Bill 173, licensure is not required until January 1st of 2027. Is it 2027 or 20? Okay,
27.
January 1st of
It's
2027.
moved
So
several
those,
times, yeah.
yep. So those provisions will be enforceable at that point.
So right now, being in limbo, there's no enforcement to that title protection.
It's not currently something that we're able to enforce because it is not
Okay.
currently required.
Okay. Okay. I just wanted to make sure that I understood correctly. Thank you so much. I appreciate your time and all you do.
Thank you so much for taking the time to come out today. Really appreciate it.
Sure. Absolutely.
Okay. Looks like Aaron Kucharek. Apologize for mispronouncing your name, but please go ahead when you're ready. You'll have 3 minutes.
Thank you very much, and thank you to the director and everyone there at the DORA for their hard work on this. In regards to the refrigeration requirements for facilities, the refrigeration unit, having a database of the serial numbers might be a little bit more than what most funeral homes can handle, as there are different units, such as like the CoolBot system that does break the circuit barrier on a window air conditioning unit to drop it down into the recommended refrigeration uh, standards. The one thing that I feel like the rules should address is that all refrigeration units need to have a refrigeration log that includes the deceased name, the date of death, the location in the refrigeration unit, clearly written and displayed on the front of the unit. And it should also have a spot for the date that the deceased was removed from the refrigeration unit, and then if they were put back in. I feel the best practice is that should be maintained by the establishment for a minimum of 3 years, and that when the state inspector comes, they should inspect and verify the information on the log for any inaccuracies. As far as the operating capacity of the refrigeration, I know there has been some discussions about having a database that's trackable. There are currently mortuary softwares out there. If a business were to offer that service to the family members, they could. However, the state is able to uh, know how many spaces are available in the refrigeration unit for the funeral home, and then be able to, if they have on the funeral home's registration online where it states how many that they can hold, and then if the inspector does show up and there are additionals, then they can be held accountable for that. As far as like the offsite storage of human remains, that one is a pretty simple one, because the offsite storage, the facility that is withholding or holding the human remains there in the offsite location, that would be considered a funeral establishment as well, and be required to have its own registration, and be set forth and held accountable to the full rules that are set. As far as with natural reduction is a form of final disposition. They still have to be registered as a funeral establishment. Natural reduction is no different than with in regards to disposition ways, as cremation, burial, entombment, and they would be held to the same standard, in my opinion and views, as a any other funeral establishment that provides any other final disposition until that disposition has occurred. As far as the advertising goes, I do think that it is very smart and good for the funeral establishment to have to remove the signs, and as well as verify the identity of the owners in their advertisements for transparency to the consumers.
Excellent. Thank you so much. I really appreciate your comments, and for addressing those questions that we presented. Really appreciate you taking the time. Let's see. Oh, another hand went up, and I'll scroll back up to or where we were at previously, but of course, please feel free to direct me to any other portion of the rules as we go through this. But the next hand up I see is Martha Thayer. You are unmuted. Please go ahead when you're ready. You'll have 3 minutes.
Thank you. I just have a couple questions to piggyback on what Aaron was just asking about. The third question that you have is what should the rules address offsite storage, or how should the rules address offsite storage of human remains? Are you referring to refrigeration when you say storage, or can you tell me a little bit more about what you mean by the word storage? The only scenario that I can come up with is that they would be in the custody of another registered establishment at another facility that would have to follow the chain of custody. So can you tell me specifically what the concern is with that, and what do you mean by storage? Or can you provide a scenario in which this might occur, and how the chain of custody would play a role in that? Because I'm not sure I understand the question.
Sarah or Sam, would you be able to
Yeah,
address that question?
I can jump in on this one. So I agree with you that the offsite storage, right, would likely be another type of licensed facility, like a crematory or another funeral home or something like that. So I guess that question is really intended to be, should there be any, should the rules address, for example, let's say a funeral establishment has a capacity issue, right, where they need to have some human remains sent off site to either another funeral home or a cremation facility or an outside refrigerate. Maybe they have an off-site centralized refrigeration building or something along those lines. For example, how and if families need to be notified of those types of arrangements, or what, if any, guidelines should there be around that type of a situation?
Okay, thank you for the clarification. The other question that I had was in reference to the advertising. When I looked at the registration that's required of funeral homes, I don't see anything in there that addresses anything in statute regarding advertising of a funeral home or what must happen when a funeral home ceases operations. And I looked through the statutes for the powers and duties of the director rules, and I can't find where it clarifies the director's authority to make rules regarding advertising at funeral homes. Can you direct me to any statutes that we already have addressed advertising specifically of establishments in, so I can read what we have?
So the rules, the statute, the statute gives the director the authority to establish rules to implement the act, right? So it's relatively broad, but if we were to write rules around advertising and what the requirements should be around advertising or when a facility closes, currently, I mean, there is inspection authority around an expired registration or when a facility is closing. So that part does exist in the statute, but we've gotten quite a bit of feedback from many stakeholders that say there should be some sort of a provision relative to an advertising requirement. So, for example, the responsible party for the funeral home should have to be advertised on any marketing or signage or those sorts of things, or the owner, right? So that's still all up in the air about what the requirement would be, which is why we're seeking the feedback. In the event that all of the rules that we're putting in place would be reviewed by the Secretary of State, not Secretary of State's office, but the Attorney General's office and attorneys as we're moving forward to make sure they comply with the statute. So in the event that through the stakeholder feedback, we draft rules for advertising, but at some point it's determined that they don't fall within the authority of the statute, then they would be taken out.
Okay, thank you. That was very helpful. And then my last comment, and I will go back and look, but you might be able to direct me there easy enough, is to piggyback on Mr. Griffin's comment earlier. I went back and looked at the fiscal note and I could not find where the fee increases for establishments were included to be that high. Can you tell me off the top of your head what page I might find that on, or where I might find it? Because I can find where it says the individual licensing fees per person, per license, but I'm not seeing where it addresses the increase, the over 500% increase of the establishment fee.
Hi, Martha. I don't know the exact page. I will look it up and see if I can
Okay.
find it, but
I
this
can
is
go
the-
back and read it again too.
Yeah, I did want to clarify that it's in the fiscal note for House Bill 1335, not in the fiscal note for Senate Bill 173.
Ah, okay, maybe perhaps I was looking in the wrong place.
Yep,
Okay,
so that's likely the issue. If you're not able to find it, feel free
Okay.
to shoot me an email and I can definitely direct you there.
okay, okay. Thank you so much. Those are my questions and comments. Thank you.
Thank you so much. Really appreciate you taking the time. We'll put you on mute. Up next, I see Ziad Zakaria. Again, I really apologize for mispronouncing anybody's name, but you should be able to unmute on your end. Please go ahead when you're ready, and you'll have 3 minutes.
Perfect. Can you hear me? I'm sorry.
Loud and clear.
Perfect. You actually said my name very, very well. So thank you.
Awesome.
Yeah, I'm actually the owner of Lighthouse Family Mortuary and Lighthouse Care Center. One thing it hasn't happened to me. I've heard a lot. I've heard people talk about it a lot, and I've heard it from other owners, other directors, other reps in this industry about the floor drain, and you have to have a floor drain. I looked up and down the entire Senate bill, and I even had my attorney read it. Nothing in there, and again, this is abroad, and if I'm wrong, please refer me to where I need to go to. I read what the embalming room requires, and I know it says a proper flooring and proper draining. And everybody, I'm assuming everybody speculated that it's a floor drain, but that's not a fact. That what's passed, it says proper drainage. Mainly, the reason I'm bringing it up more than anything, but some of the facilities we either lease out, or some people who have been in their entire facilities for 50, and I know it was directed last meeting, where we can't start putting drains in facilities, but we do have proper drainage. I mean, 99% of embalming rooms, they have embalming stations which has proper drainage. Proper drainage, really, all it is a system of water or waste liquids moving from your building or facility into the sewer lines properly. And we all have them. I would assure, at least for us, we do. And I'm speaking on other funeral homes that I've been involved with. They do. I just need to know if that is a fact, because I mean, if the inspectors are going and signing infractions on funeral homes for not having floor drains, that's not what the rule says. So I just want to kind of get clarification on that, because it should be just proper drainage. And if that is the case, hell, a sink against the wall is a proper drainage. Toilet is a proper drainage. Embalming machines is proper drainage. You don't need a floor drain to do what you need to do. And that's all. I just want to make sure that's what the state meant, because we can't, if inspectors are going out around inspecting buildings, they can't use their interpretation of what proper draining it is. It should follow the rule of law. And that's my question and my comment, I guess.
Yeah, thank you so much. I appreciate you raising that issue.
I
did just want to point. Oh, Cam, go ahead, please.
Sorry. So, yes. So we have gotten some of that feedback as well, and we appreciate that. The rule will be intended to account for those sorts of things. We are not necessarily expecting that everyone who is currently operating with effective drainage, like you say, like you've described, is going to have to drill holes in their floors and all of those sorts of things in order to accommodate. What we're trying to do through this process is to put some parameters around, as you mentioned, what proper drainage actually looks like, so that the inspectors and obviously the establishments have some guidance in terms of what it looks like. But to your point, it doesn't have to look like a floor drain, right? And all of those sorts of things. But that's what we're trying to figure out, what it should actually say.
I appreciate that. And again, I know it's a learning curve for everybody, and this is why we're doing this. So that way it's black and white and not interpreted by individuals. I was a fire inspector for 5 years. I have my own interpretations. I'm always wrong when I go into inspect the building, and they're like, no, that's your interpretation. So I just want to make sure we're all on the same page.
Yeah, absolutely. And to that point, I did just want to point you towards this update that we made here, replacing the word floor with functional.
Oh, perfect.
In my opinion, that I think addresses those concerns, but would like to hear folks' feedback on just that word functional, if it should be functional or appropriate, or any suggestions along those lines would be really appreciated for sure. But I do think, at least in my opinion, functional drain, I think, starts to address those issues.
Perfect. Well, I appreciate it. Thank you so much.
Absolutely. Yeah, thank you for taking the time. All right. Let's go ahead and call on the next person here. It looks like Shelia Canfield-Jones. Your hand is up. You should be able to unmute. Please go ahead when you're ready. You'll have 3 minutes.
Hi. I wanted to go back to what Martha Thayer was saying about the advertisement. As a consumer, most of the institutions or things we use, we want to know who the owner is. Unfortunately, DORA's not providing us with that information, so we have to go back into the state and look to see who owns a corporation, which a lot of people don't know that process anyway. So I think it's very important in any pamphlets they put out, anything they have in the inside the funeral home, that it has who the actual owner is and a way to contact those owners in case we see some kind of problem or have a problem with the funeral home. I think that's extremely important to the consumer. And it's also done in other industries, so it's nothing new. It would be nice if DORA had a database that we could look these things up, but unfortunately, I don't think that that's going to be provided. We'll be lucky if we get a database that we can see individuals and how they're licensed and what license they have. So that's all I wanted to say about that. As far as drainage, some of these things as a consumer are very technical to us, because we're not in the business. We're using the business and paying for the business, but that's it. So I think every funeral home should have the same. There shouldn't be any grandfathering of any rule or any smaller funeral homes. They should all be the same. They should all have the same requirements in order to provide safety and provide for the consumer. Thank you. That's all I have.
Thank you so much. I appreciate your comment. Okay. Well, I don't see any additional hands raised at this point. I will lean on the team to see if there's any comments that we should read aloud for everybody. Looks like we've been addressing comments on the back end there, but just wanted to check to see if there's any that we should maybe read aloud. Okay. Well, in that case, I will go back up to the top and we can keep sort of working our way through it, see if there's any issues that pop into your mind as we scroll through these. Let's see. Oh, let's see. I got a hand up from Jason Hopfer. Please go ahead and unmute when you're ready. You'll have 3 minutes, sir.
Jason Hopfer on behalf of SCI. I wanted to go back to a question I asked at the previous meeting that I don't think was addressed, and I'm just curious as what the division wants to do when it references designee. Would that be someone on staff or a third party? And the reason I ask that is I think there's some concerns that if you have a third party who's part of the industry, that you end up with competitive issues that are concerning.
Hi, Jason. Are you referring to the designee? So each establishment is required to have a designee. That would be
no. I was referring to the part where I'm sorry, I don't have you. You just scroll past. It's at the very beginning.
Right. I believe, is it rule 1.4?
Director or the director's designee. Because when you're referring to the director doing inspections and saying or the director's designee, I just want to make sure there's clarity about whether that designee in the case of coming out and doing inspections is someone on staff or a third party. And if that's a third party, are you going to make sure that there's no competitive issues between entities that are doing inspections?
Okay, thank you for your clarification. So the director's designee generally refers to the inspectors that will be going out who are DORA employees. However, we do also have the, excuse me, we do also have the ability to hire expert consultants in cases where, you know, we're not sure, we don't have the expertise necessary. So definitely appreciate that comment, and that's something that we can consider for the rules, but that is what that is kind of referring to.
Thank you.
Yeah, thank you so much. Really appreciate you taking the time today. All right. Well, I don't see any additional hands raised, and looks like we may have taken care of all the written comments at this point. So we just keep scrolling down. Let's see, I have a hand up from Christina, David's mom. You should be able to unmute on your end. Please go ahead when you're ready. You'll have 3 minutes.
Hi, I'm sorry if this isn't the appropriate time for this question. I jumped on a few minutes late and my signal is pretty bad. So if I lose you, if you could look at the comments that I wrote. What are we doing to address secondary identifications during the change of custody at the crematorium, and also the crematorium reporting back? I think that those two things are two of the things that could have prevented the return to nature fiasco, because there wasn't any record of or any way to compare the death certificates that were issued versus the cremations that had actually been completed. So I would like to know if that's being addressed in any of this.
Sarah, would you like to address that?
Yeah. Can you scroll down? There are rules around chain of custody. So if you can kind of scroll down to those. Christina, if you want to take a look at what is in the rule, if there are suggestions that you have for improving that, we're definitely interested in hearing, you know, what those are, and certainly considering including those. If you don't feel that it's, you know, what you're referring to. Obviously, this will require some coordination with CDPHE as well. They're the ones who issue those permits, and that is definitely something we are working to do for sure. But we're absolutely interested in any suggestions you have to improving what we already have here.
Awesome, thank you.
And yeah, just so you know, it is in proposed rule 1.22 right here. So you can go and take a look at that.
Thank you. I will look at that again as well.
On our website. Yeah.
Yeah, starting on page 20. So, I mean, as you can imagine, as other people have mentioned as well, right, there is a separation in, well, I should say there's a point at which the DORA regulations stop and the CDPHE regulations begin, particularly when it comes to some of the disposition aspects of human remains, and as others have mentioned, the permitting system and that sort of a thing. And do you get a permit? Do you have to close a permit? Those particular provisions are outside of the regulatory authority of DORA. So we don't even have the ability to make rules around those particular things. But to Sarah's point, we have had conversations with CDPHE and talked to them a bit about where some of the gaps might be that will need to be filled at some point.
Thank you, Sam.
And thank you so much for taking the time to come out today. Okay. As we were scrolling through, I did want to highlight, we got quite a few comments, or at least a good handful of comments with respect to the criminal conviction issue here. So I think I did just want to kind of, I think, clarify some confusion about what this proposed Rule 1.16 is attempting to achieve. So under the Practice Act as it stands now, there is a whole list of criminal convictions that are built into the statute that are considered to be disqualifying or potentially disqualifying at the very least. This rule here, Rule 1.16, is simply taking the portion of the Practice Act that says director you should look at these A, B, and C and determine whether or not those should be also disqualifying. So one of the actually pretty much the only question we got about this particular question is a comment saying that we should include abuse of a corpse within this rule. And the reason that it's not included here is because that crime is already considered disqualifying under the statute. And so there's no reason for us to include that portion here as well. It would just be regurgitating what's already in statute. And we try to keep our rules as sort of concise and tight as possible without, again, just restating what's already in statute. So if you're wondering why that particular felony isn't included, or that particular criminal conviction isn't included here, it's simply because it's already covered in the statute. So I just wanted to touch on that as we were scrolling through here, and again, assure the public that that abuse of a corpse is taken very seriously and is already included as one of those disqualifying convictions. Let's see. I do see Martha Thayer. Your hand is up. You should be able to unmute on your hand. Please go ahead. You'll have another 3 minutes.
I just had a quick question about, I'm noticing that this document is dated October 22nd. And when I look on the Mortuary Science homepage, the most current red line update is dated in September. And so will we have an opportunity to look at this updated document before the meeting next Friday to see if any of the other suggestions, just to be able to compare? For example, I'm curious if the issue was addressed that Beatrice Cremation and some other people brought forward last time in terms of should there, if there's going to be a requirement that a embalming room has to be at every facility, whether or not they even offer embalming as an option.
Yeah, that's a really good question, and I think it might just be a file naming issue on our end. You should have the most up-to-date rules, red line rules available on the website, but certainly we will make sure that they are available.
Yeah, please double check, because I just pulled it up and it's showing the old version of it. So I think it is a file issue.
Okay, yeah, we will certainly deal with that directly after this. And thank you so much for alerting us to that. And we will certainly take care of that after this. And the public will definitely have an opportunity to take a look at these after this and how they've evolved, certainly.
And I just wanted to mention too, sometimes browsers will cache old documents, so you may need to make sure that it's not, your browser isn't caching the old one.
Sure. Okay, I'll double check that. And then can you show me in this document where you've addressed the issue of funeral homes who establishments who do not offer cremation being required to have, I'm sorry, that do not offer embalming being required to have an embalming room?
Yes. My apologies. It's a long document to scroll through. Here we go. So this is where, and actually this, going back to look at the statute, this was actually an oversight on our part, quite frankly. But I added this language here: every funeral establishment that performs embalming must maintain a clean and sanitary preparation room. So I believe that should address that concern.
Okay, thank you.
Easy enough with 3 words to do it. So hopefully that takes care of that concern. Yeah, thank you so much.
Yep.
All right. A hand up again from Aaron Kupcharek. Please go ahead, sir. You'll have 3 minutes.
Thank you. One of the things that I have discovered is some funeral homes are not updating their registration, the address of their business. I know of one funeral home in the Colorado Springs metro area that has moved locations twice now in the past 2 years, but their address is still the original address of the establishment and not updated to their new one. I don't remember seeing anything in these rules about the requirement for the establishment to update that. And a time frame for that, and it may be covered under something else. So I do apologize if it is covered under a different statute or something of that nature. So I didn't know if that was something that needed to be addressed in the rulemaking process here.
Sarah, I don't know if you wanted to weigh in this, but I do believe we included language to that effect here in 1.18 or proposed 1.18.
That's what I was just checking too. I'm pretty sure it's either in here or it's directly in the statute. So I was just trying to find that. And if I do find that, I will definitely chime in. But yeah, that's what I was looking for as well. Because I do believe it's in here.
And it very well could be. I've read it about 4 different times, but you know, I am a funeral director by education, not a legal rules professional.
Yeah, absolutely.
So I do apologize.
With me, I've read them so many times that I don't remember for sure. So I'm gonna try and find that, and I will chime back in if I do.
All right, thank you very much.
Thank you, sir. Really appreciate you taking the time, as always. All right, let's go ahead and looks like Blanca Eberhardt. You should be able to unmute on your end. Please go ahead when you're ready.
Yes.
We'll have another 3 minutes.
Thank you. I didn't introduce myself last time. I do apologize. I've been actually practicing, not just education wise, but hands-on funeral directing and embalming for over 20 years. So some of this stuff to me kind of just feels like second nature. And I feel like we're almost getting hung up in the rules part of where the embalming and the refrigeration. As a licensed, I'm licensed in Indiana, Texas, and Hawaii, funeral director and embalmer. We all know just that refrigeration is so important. So many times you're going to hear, oh, well, this firm doesn't have an embalming room or it doesn't have refrigeration. The point is that you have to find it, whether you partner with somebody else or whether you have your own refrigeration. It should always be at the forefront to refrigerate, because whether they're choosing some type of green service, which just is the type of service, every funeral home can do green services. It's just, it depends on your marketing beliefs, your spiritual beliefs, all those type of things. But for rulemaking process reasons, it's still handling human remains. And not everybody is going to qualify for a green service, and they might not know that until they get there. So how are they going to handle this loved one? So you have to have refrigeration in your establishment. I think as rule number 1, if you're going to handle human remains, that's more important whether you provide embalming or not, if that makes sense. Because embalming is a type of service and not everybody has to have it. But if you do pass away of a contagious disease, you have to be careful of the staff, the public, and so forth. So I think maybe that's something as a suggestion to think about with our wording. And that's all I have.
Yeah, excellent. Thank you so much. Appreciate that comment. Okay. I don't see any hands raised at the moment, so I will scroll a little bit further back up so we can maybe start to go through this again. Oh, got a couple of my hands up.
Just really quickly before we go to the next comment, Aaron, that requirement is in statute. It requires a specific location for the registration. So it is in, shoot, I have to find the right tab. It is in 12-135 2A Roman numeral 1.
Awesome. Thanks, Sarah. Appreciate you finding that.
Yep.
Let's see, got a couple hands up. I think first up I saw Lenny Griffin. Please unmute when you're ready. You'll have another 3 minutes.
Hey, I just wanted to piggyback on what Blanca said. I think she's 100% right. Over the years in Colorado, I've been in the industry 33 years in Colorado. I have seen all kinds of coolers. I didn't really think it would go this far into maybe having so many rules with regards to a cooler, but I'm seeing places over the years that literally have framed out a closet in a garage and put a window mount cooler in there with a quote unquote cool bot. I've also seen establishments that have swamp coolers in them, and I think part of the problem that I see is just they're not able to maintain the temperatures. The coolers that I have in each facility, I've spent anywhere from $55,000 to $75,000 on. you have to be able to maintain, if it's 100 degrees outside, that it still stays, the relative temperature inside of the cooling unit, right? So if you put a window mount in and you come in and inspect that cooler, which I know you guys have in certain establishments, where the cooler will actually show that it's 32 degrees inside, but it's 40 degrees outside, as to 110 degrees outside, and it's actually 80 degrees inside the cooler. So, I just think there should be some regulation generally with respect to the type of refrigerant that's used. And I know it's a good thing to put on that you have a temperature display, but it doesn't necessarily require the maintaining of the temperature within inside the box. And that's really all I have.
Great, thank you so much for that comment. Let's see. I believe Thomas Murphy, you are next. You should be unmuted on your end. Please go ahead. You'll have 3 minutes. Thomas Murphy, you should be able to speak. Should be unmuted. But I am at least not hearing you speak at this point. I'm getting head shakes as well, so might be having some technical difficulties, Mr. Murphy, but please keep trying if you're able. Well, why don't we go ahead and we can keep trying on that one, but I think we'll move on, since it seems like we're running into some technical difficulties there. And Thomas Murphy, if you're not able to unmute, of course you can always feel free to just type your comment or question into the Q&A section, and we can address it that way as well. It does seem like we're not able to hear you. Okay, let's see.
And he does have a question in the written part that
okay.
I'm working on a response for you.
Okay. Scroll back up. Absolutely, Mr. Murphy. I believe Sam is working to get you an answer to that question for sure. And that, yeah, technical difficulties never fails. Let's see, there were some other comments that I did want to address as to sort of why we can't necessarily respond to some of these comments, at least. So some of the comments that we received do pertain to sort of how a hearing might go and who has the burden of proof. If there is a hearing, and I was trying to find it as we scroll through here, but I did just want to address that here, because there was some suggestion that we should sort of act to in some capacity as to help the petitioner prove their case. So some suggestions that we should do some of the gathering of evidence to try to meet that burden of proof, should there be a hearing in a complaint. And just given the position of DORA as the arbiter of these issues, and rules around due process and how these hearings are conducted in an adversarial manner, it would just ultimately be legally inappropriate for us as the regulator to get involved in that capacity, in terms of trying to prove a complaint. So I did just want to put that out there because again, we did receive at least a fair number of comments along those lines, and just kind of wanted to explain why we can't necessarily add that sort of language into these rules. It's just, again, kind of baked into the overall structure of our constitutional order here in the state. And I don't see any additional hands raised at the moment. So let me just scroll back up to the top. We can keep coming down. Anything we pass sparks an idea or comment. Of course, feel free to raise your hand. Okay, I think we've gotten to where we were. Coming down here, you'll see that we added this language here, disclosures. This disclosure language was just inadvertently left out of the requirements for mortuary science practitioners. So appreciate y'all catching that oversight and similar oversights. That's why we rely so heavily on stakeholders. And I don't see any additional hands raised at the moment. I don't see any questions either. So we certainly don't want to belabor the point if there's no other comments or questions. We do have about half an hour left in our scheduled time, so also don't want to rush anybody if they're compiling your thoughts or typing out a question or comment. Certainly have plenty of time remaining, but also don't want to waste anybody's time either. So if we don't see any additional hands or questions here in the next minute or so, I think we can probably close this out. But I did just want to take a moment to sincerely thank you all for coming out today. Again, I know it's a Friday morning, Friday after Halloween, and it's not always convenient for you to take your time out of what is, I am assured, your very busy schedules. So it's really heartening for me as a civil servant to see so many folks come out and be engaged in this process as we try to get these rules in place and make sure that we are regulating the industry in a way that is fair for everybody, consumers and licensees.
The other thing that I will say for the benefit of the group is, this initial rulemaking and certification of these rules are meant to get the program running and enact the provisions of the statute. We want to be clear that we fully expect that there will be a need to come back, right, and do additional rulemaking and gather additional feedback as we continue to talk with stakeholders in the industry and family groups and all of those sorts of things. So we want to get this initial set of rules published so that the industry has some expectations and understanding of where things are going. And our goal has always been to provide that level of consumer protection that we've talked about while ensuring that the industry has the ability to continue to operate and people have the ability to comply with the licensing provisions. But we fully expect that over time we will need to address varying aspects of the rules going forward as well.
Yeah, absolutely. Thank you, Sam. That's really good context. One of the benefits of having rulemaking authority is that we can come back and take a second look at these as needed, for sure. One, I did notice a question with regards to the qualified peer reviewers. We did get quite a few comments suggesting that they be required to be a resident of Colorado. So you can see that has been added there. I forgot to put that in bold, but they're addressing that concern, certainly. We did get this written comment here from Jason Hopfer, wondering about the use of the term foreign here in this section dealing with endorsement. So as used in this context, a foreign license would be, it's a term of art, meaning any license issued by a jurisdiction other than Colorado. All right, so to the extent that that's confusing, certainly can understand that from a non-attorney's perspective. So, and change that to non-Colorado license, just to try to remove any sort of confusion or ambiguity about what we referring to there. And I am not seeing any additional hands. Check to see
Nate, I'm not sure if you saw the comments in the written comment regarding continuing education rules. Can you scroll down to that and comment on if there have been any changes?
Certainly.
Thank you.
Yeah, I don't think that we had made any changes to this particular rule. I may not have gotten any. Oh yes, so actually we did. So here we did get one comment. It was thank you for the reminder there. It was with respect to the organizations, the authorized organizations. So you can see it came in and took out those organizations that based off feedback don't have anything to do with continuing education. And then added in those suggested organizations. But certainly if anybody has any additional organizations that they think should be included there, although of course this handy dandy language here at the end allows the director to, as needed, approve any additional organizations for CE purposes. But I believe that was the only change we made to this particular proposed rule.
I think there's one further up too related to in-person credits.
Oh, that was, yes, thank you. There's so much going on with these. Where was that? It might not actually be in this rule.
Yeah, I just remember in reading it yesterday, and I'm not sure which rule it is. We'll find that citation. I know Nate's looking through it, but I believe the requirement is 6 hours of continuing education now as written, 6 hours of continuing education with 3 of those hours happening in person, if I remember correctly from what I read yesterday.
That sounds correct. I can't remember the portion that is contained in. And I did see a hand go up and come down, so maybe we addressed your comment or question just in our back and forth here, but of course, please raise your hand back up if you would like to speak. It looks like all of our written questions have been taken care of. And I did also just want to add that in case you're wondering, in addition to this being recorded, we do have a staff member in the background taking notes and making sure that everybody's comments are being recorded in writing as well, so that we make doubly sure that we're capturing everybody's comments.
And I did find that rule I was referring to in regards to the in-person requirement. It is in 1.11B2.
Perfect. Thank you. So we did, looks like we got a question about inspections. So we did make a few changes here to that provision of the rules. So we did get some comments suggesting that that inspection authority should be at any time, including during non-business hours. And this was just some clarifying language there to make it read a little bit easier. And we did get some questions about the frequency. Excuse me, the frequency of inspections. Some comments suggesting that it should be at least twice per year. And as you can see, we still have it here no less than annually. So I don't know if Sarah or Sam, you'd like to speak to why we are keeping it at annually, but certainly would like to hear any comments or questions you might have for why you think a greater frequency would be more appropriate.
You mean in terms of the length of the license? That's what you
well, so yeah, there were some comments suggesting. So I just wanted to see if you wanted to address that issue.
Sorry, I couldn't hear your comment. Say it again.
Oh, there were comments from the public saying that we should have a biannual, so twice a year inspections rather than just once a year. That makes sense.
Sarah, correct me if I'm wrong, but I think the statute specifically calls for during the renewal period, right? So between renewals, they're required to do an inspection.
Yeah, so that the statute says that it should be set in rule, the frequency for the routine periodic. It's routine periodic is the words used in statute. So this is something that is set in rule.
So I think initially it's going to the goal is to go along with the renewal period, right? So, through each renewal period, the facilities will be required to undergo an inspection, and then it could be periodic at any point. So I don't think people should fall into the illusion that everybody's only going to have one inspection every year or every 2 years. You could be inspected at any point throughout your licensure period.
Yeah, and just to sort of piggyback on that, in addition to the routine periodic inspections that we're discussing, people or establishments are required to be inspected on initial application. So if it's a new facility, it's required to be inspected at that point. They are required to be inspected at any point that they do not renew their registration or that their registration lapses or becomes invalid for whatever reason. And then they're also able to be inspected on complaint or on the director's own initiative. So there are several cases where a facility could be inspected.
Perfect. Yeah, thank you so much. I appreciate you providing that context. And it does seem like as I scroll through, we're getting some additional questions and comments. So I will continue to do this until we reach the end. We do have about 20 minutes left in our scheduled time, so certainly have some time remaining. I'm trying to remember if there were any other changes that we made that I should highlight here. I don't think so. We've already covered quite a bit of this. We did make some additional changes here to the federation room requirements. Got some, equivalent. Not everybody. Some people are allergic to latex. We understand that. And then not everybody uses those heavy latex gloves necessarily in every situation. So nitrile gloves as well. We are also alerted to sort of terminology issue there instead of sanitizing rather than a stronger language that we had in there earlier. Again, you can see we changed floor drain to functional drain. We did, in terms of the refrigeration requirements, we did get some feedback that 44 degrees was too high, and that the standard is actually at most 39 degrees seemed to be the appropriate standard there for the industry. And that brings us to the end. So I didn't see any additional hands go up through all of that, and I think let me check to see if we've addressed all of the Q&A question. Yep, looks like there's a question being addressed now. So I will go ahead and keep the comment section going, comment portion here going for until it reads 11:15 by my clock. And I think we can probably wrap this up unless we start getting another bevy of questions here. But again, I did just want to take a second to really express our appreciation for you taking the time to come out today. Really couldn't do what we do here without input from the public. Really appreciate it. So we did. So I rest assured, you can this particular version of the most updated version. It should already be available via a link on the website for the Funeral Services and Mortuary Science Services website. If you go to I think it should be under the public notices drop down. It should have a link to the red line version. And we were alerted that it might have been a hiccup with the version that we have up there currently, but we will be uploading this most current version after this, and you will be able to access it through that.
And I did add the link. Someone asked that question in the written question, so I did add the link to the specific page as well.
Perfect. Thank you so much, sir.
Version you're going to go through when the rulemaking hearing is, and then this version of the rules will be published in that notice as well, right?
Absolutely. Yeah. I'll close out the hearing here with a little script for next steps for sure. All right. Well, I think we have exhausted all of the public comment for this morning. So why don't we go ahead and close out that portion of the meeting. All right. So thank you so much for participating in today's meeting. As part of this collaborative process, all comments and program recommendations will be provided to the director for review. Any proposed revisions will be made available to stakeholders for additional comments prior to the rulemaking hearing, which is scheduled for November 7th, 2024. All rulemaking information can be found on the program's website under the Public Notices tab, and written comments may be sent to Dora_DPO_rulemaking@state.co.us. Again, that is DORA_DPO_rulemaking@state.co.us. That concludes the stakeholder meeting. Thank you again for your participation.